reconvene this Tuesday, September 26th meeting of the Board of County Commissioners and mention that Commissioner Lycan attended a lunchtime meeting in Springfield and may be running a minute or two late, at least a few seconds late. So he'll be stepping in 5, 4, there he is. Perfect. Good afternoon. Welcome to Harris Hall. We have a number of items on our agenda, 3 public hearings today. Thank you, Mr. Rickoff. The first item on the agenda this afternoon is a second reading and public hearing on ordinance number PA 1355. When it comes time for the public hearing, I'll read the rules of the public hearing. And at this point in time, Mr. Rickoff, today we have with us Lindsay Eichner. Ms. Eichner, we'll have a staff presentation and then questions from the board.
Actually, I would be great if you could start the script.
Okay, very good.
And then part of that is I'll give my.
We have a second reading and public hearing on ordinance PA 1355 in the matter of conformity determination to recognize and correct an error in the original designation and zoning of the subject tract, amending the rural comprehensive plan to redesignate land from forest land to natural resource mineral, to rezone land from non-impacted forest land F1 to quarry and mine operation QM, and adopting savings and severability clause. File 509 PA 16-05327. The applicant is Weyerhaeuser Company. Ms. Eichner, thank you. And please, if my hand needs to be held, that's fine.
So I think
the explanation purpose.
we have to. So I'll speak at number 5 on the.
Thank you.
List. Sorry.
Yes.
Thank you.
You mean where it says here report by staff? Okay. Gotcha. Then the explanation and purpose of the public hearing. This decision is subject to plan amendment and other criteria cited by the agenda cover memo and attachments, and evidence and testimony must be directed toward the approval criteria, and failure to raise an issue to enable a response may preclude appeal to LUBA. This is the opportunity for those present to enter information into the record. Only persons who qualify as party may appeal the board's decision to LUBA. At this moment in time, I will call for disclosure of board member ex parte contacts and for abstentions due to conflicts of interest, ex parte contacts or biases. Commissioner Sorensen.
I have none.
Commissioner Bozovich.
Well, I did happen to sit next to Greg Miller with Weyerhaeuser on a tour yesterday. We never discussed this application at any time, and I have had no contact about this application from Weyerhaeuser.
Thank you.
No conflicts.
Thank you, Commissioner Bozovich. Commissioner Williams.
I have no conflicts.
Commissioner Lycan.
I shook hands with Greg Miller on the same tour yesterday, but other than that, we did not discuss this, so none.
Thank you. And even though I shook hands with Greg Miller a number of years ago, I have none. So at this point, we have no conflict of interest. Thank you, Mr.
Oh, Mr. Chair, I shook hands with George Weyerhaeuser when he came to Eugene to celebrate the 50-year partnership between Weyerhaeuser and the paper industry in our community.
I'll need to call for a ruling on that, Mr. Clark. I think we're okay with no conflict of interest. Thank you. Ms. Eichner.
Good afternoon, Chair, FAR, and Commissioners. Before you today is an applicant-initiated request for a minor plan amendment with a concurrent zone change. The Rural Comprehensive Plan was adopted in 1984, and Goal 2 Policy 27 has criteria around a conformity determination request if the property owner believes that the county incorrectly designated a plan or zone for a specific property at that time. In the mid to late 80s, this was a very common practice. The county has, over the years, has tried to correct as many of these as possible, but there are a few lingering out there, and this property owner believes that this is a good case, a good application to make under this criteria. The subject property is known as Assessor's Map and Tax Lot Number 17093000, tax lot 201, located just north of the unincorporated community of Swiftsholme. To your left, my right, we have a before and after or a current and proposed zoning map. So the subject property is outlined in dark black. The current comprehensive plan designation is forest, and the zoning is F2 or F1, non-impacted forest land. It contains an old quarry, which first obtained a Dogami permit in 1979. It was first zoned forest management later that year in 1979. And then just after it was zoned, it reconfigured itself and through a minor partition. And at that time, it was all tax lot 200, and then they deeded off the larger piece, which has now become tax lot 201. That was the new tax lot number was given by assessment and taxation, and but the applicant or the property owner and land management staff still were referring to the property as tax lot 200. There was a little bit of delay in communicating the tax lot number change. In 1982, tax lot 200 was called out as a resource site in the Mineral and Aggregate Resources Working Paper for the Comprehensive Plan. The current tax lot 200, there's no evidence that a quarry ever existed on that property. In 1983, the proposed zoning maps went out for public review prior to adoption. In December of 1983, the owner's attorney submitted information to petition the county to zone the property QM rather than F1. And that was approved. That request was approved for tax lot 200, but the legal description attached to that approval was the description of current tax lot 201. On February 29th, 1984, the county adopted Ordinance 884, which designated the current tax lot 200 as as QM and 201 as F1. In 1989, the property received approval for a verification of non-conforming use that acknowledged that there was a quarry on the property. And again, in 1999, land management acknowledged that there was a quarry on the property based off permit records. The applicant has submitted a current Dogami permit for the quarry that's on the subject property. So all of the information combined with the evidence in the file, we support the idea that this is a scrivener's error during the zoning and mapping process of the early 80s, and that the subject property was meant to be zoned QM. Staff recommends option 1 and approval of ordinance PA 1355. Thank you.
Thank you, Ms. Eigner. Questions or comments prior to opening of the public hearing? Commissioner Sorensen.
Notice that there's a letter in the file that's on the website. See what page that is, if I can find it. I can't identify what page it is on my computer, but I can tell you it's a letter dated February 21, 2017 from Jeremiah Ingersoll, who is the forest supervisor of the Sayusla National Forest. And he's writing a letter, Dear Lane County Planning Commission, upon reviewing the proposed change in zoning for the quarry owned by Weyerhaeuser, the Sayusla National Forest has concerns. Should the change in zoning allow for expansion of the quarry, the rock quarry is currently accessed by an unauthorized road and is encroaching on the National Forest System land as documented in the 2008 survey, CS file number 40,904, filed in Lane County on February 4, 2008. So is this accurate? And has it been resolved? The letter also says they'll be working with Weyerhaeuser to resolve this matter.
That is accurate. There is a road that goes up onto the National Forest land. I'm going to defer to the applicant's attorney to address that concern, to see where they're at. I know that they were going to be talking to them after our planning commission public hearing when this was submitted. I haven't heard follow-up on that.
Is the activity outside of the proposed zone change even relevant to this hearing? In other words, that has to do with the dispute over, the use of public land,
Right.
National
That's
Forest land.
Just access. They're not, from what I understood, they weren't mining on that area. And so I don't think it would affect the zone change request or the plan amendment request, because if they got an easement, then they could potentially use that to access their operations.
And if they don't have an easement, it doesn't involve Lane County zoning activity. It involves a possible dispute between Weyerhaeuser and the National Forest.
Right.
Okay, thank you.
A question regarding the letter, is that in the record, the letter that was just cited?
Yes.
Inside of the record?
Yes.
Thank you.
It's part of the planning commission packet, I believe.
Very good. Any further questions or comments prior to opening of the public hearing? And at this point, I will open the public hearing. We'll be assigning a 3-minute, once we get into the actual public hearing, a 3-minute time frame. First, we're going to hear the applicant's testimony and then testimonies from persons in favor, followed by testimony of other persons, and then we'll hear additional comments by staff and a rebuttal, if any. So at this point, Ms. Lindsay, I'd like to hear the applicant's testimony. Excuse me, at this point, I'd like to open the public hearing. I will now open the public hearing on PA 1355. Thank you. Please identify yourself, name and address for the record. Thank you.
Everybody's so much taller than me. Kim O'Day, Law Office of Bill Close, 375 West 4th, Eugene, 97401. I represent Weyerhaeuser. This particular application is, to answer your question, Mr. Sorensen, the access issue has to do with use, and we're getting that resolved. You can see the road is the one that pops up north. That's the issue there, where the roadway comes up north out of our property and drops back down. That relates to use. This is just going back and fixing an error, so it's not relevant. This one is nice and clean. I don't have a lot to add, so I'm going to sit down. The reality is the entire thing was zoned tax lot 200 back when all this stuff was happening, and it took a while to catch up, and then people were still calling it something different because assessment and taxation hasn't quite caught up with what had happened with the partitions and land divisions. And then suddenly there's this zone change request that went in to deal with going to QM. And the wrong tax lot number got put on that request that was approved, but the legal description attached describes the subject property. And that makes sense because there absolutely is no quarry on what is now tax lot 200, so it could have never made it on the inventory in the first place. So really, this is one of those just simple situations where things got a little bit muddy and the wrong piece of property got zoned QM.
We like simple situations.
We love simple situations. I don't get simple situations very often.
Excellent. Thank you, Ms. O'Day. Any questions? Please,
The last comment is that I at the very last minute this morning, I got 15, 20 pages of material from opposition. I think I've responded to all this in the past. It looks kind of redundant, but I suspect we're going to be asking to leave the record open to address it, just because we don't want to run off to another world without addressing all the issues that the opposition brings up. I wish they'd have come a lot sooner. This application's been pending for almost a year. Nothing's changed. It would have been really nice to have all this stuff out in the air and have it all done before we got to you today, but apparently that's not the case.
Excellent. Thank you, Ms. O'Day. At this point, I will invite testimony from any persons in favor. On my list, I have no persons in favor. If anyone in favor is in the audience and wishes to testify, please do so. Please identify yourself at this time. I see none. Then we'll hear from testimony of other persons. And I have one person signed up. That will be Sean Malone. And please, Mr. Malone, let me know if it's not Malone. Thank you.
Good afternoon, Sean Malone on behalf of Landwash Lane County. We participated before the Planning Commission. Real quick, my address, 259 East 25th Avenue, 200C. I don't think this is a very straightforward application. We're talking about a mistake that allegedly occurred 30 years ago. I think first off, we need to ask ourselves, why did it take so long to come to that understanding after there's been numerous land use applications on the property? Why is it only now that we're sort of understanding that there's some mistake that occurred? With regard to the CPR document, it really is not something that is approved or not. It was there was no process for approval. There's no notice for it or anything like that. It wasn't a land use decision. I don't think that there's really any effect to that, except to say that what they requested, they got. And they're now coming back and saying that was a mistake. And they point to alleged mistakes in various areas, but the sort of likelihood of all of these mistakes coinciding in one application over and over again seems to me to be a bit unlikely. But to move forward with fundamental errors in this application is that I think the first and foremost one that I don't think Ms. O'Day's addressed yet is that ordinance number 1884 that rezoned this property, that was a final land use decision. And you can't go back and attack final land use decisions that have occurred, especially those that happened more than 30 years ago. If the applicant was unhappy with the designation of the property at that time, that was the point in which to appeal that to the Land Use Board of Appeals and then go through that process. They did not do that. And that is what we refer to as a collateral attack on a final unappealed land use decision. So that right there should stop this in its tracks. That's a matter of state law. The application here is being processed under a RCP provision. So I don't see how some allegation of mistake 30 years after a final unappealed land use decision can stand. I couldn't mount a collateral attack against something that occurred 2 months ago, let alone 30 years ago. Beyond that, we've got lots of issues here in what I've submitted into the record, what we submitted before the Planning Commission. But I think apart from this collateral attack issue, what we're dealing with here is a zone change, and the staff report acknowledges that we have to address all the statewide planning goals. And if you look at the proposed findings here, none of the statewide planning goals have been addressed at all. Most glaringly, there is statewide planning goal 5, which should have been addressed if this weren't such a big mistake. So at the very least, that needs to occur in addition to the compliance with the rest of the planning goals. Assume that's my time. Is that?
I'll grant you a little latitude.
Yeah, thank you. And really, I just wanted to hit some of the highlights that hadn't been addressed previously. I guess the final thing I'll say is when these significant aggregate resource sites were identified, the applicant is now saying that those were all identifying existing aggregate mines at the time. There's nothing to establish, at least in the record from what I can tell, that there's any evidence of that the designation was referring to sites that were currently being mined. So that's something that the applicant's alleging that's just simply not supported in the record. But I think everything else can be found within what we've submitted, but I think the paramount issue is really this collateral attack on a final unappealed land use decision from 30 years ago. And with that, I'll...
Thank you, Mr. Malone.
Thank you.
Additional comments by staff? Ms. Eichner?
My apologies for not bringing this up. I was only notified a couple minutes before the hearing that additional comments were submitted by email today. I have not been at my desk. I had other meetings this morning, so I was not aware of them.
Okay.
So I will forward them on, or they will be made part of the record.
Thank you. Excellent. Then I'll invite applicant rebuttal of the testimony. No need to restate your name, Ms. O'Day. Thank you.
Excellent. Collateral attack issue is fully briefed already in your packet. He misunderstands the concept of a collateral attack, and that's fine. I would, with regard to the rest, I would rather address that in writing. I believe that everything in the application has already been addressed. Most of his concerns have already been addressed, but we might as well get them in writing so that they're in the record and we're not arguing with them over here. So I would like to request that the record get left open. Doesn't have to be a long time, maybe a week tops.
Very good. Okay. Thank you very much. I'm sorry. Oh, Commissioner, at this point, I'll invite questions or comments from the board. So, Commissioner Sorensen.
Perhaps Andy could weigh in on the legal issue of what is the proper procedure, in your view, to make corrections in a land use zoning document, and what do you make of the idea that there's a time period in which you can appeal, which seems to be what we often deal with here, but how do you make changes then in existing zoning without appealing the decision of the board or the planning director or the planning commission? Can you help us rectify the legitimate concerns of the property owner that, hey, there was an error made, we discovered it 40 years later, 30 years later, we're trying to fix it, and can you rectify the rights of the neighboring property owners who they were relying on the previous decisions long established to establish the zone?
I'm not as familiar with the code section and the statutes that govern this case, and so Ms. Eichert's probably in a better position to answer that in detail, but this doesn't strike me as a matter where we're talking about the expiration of an appeal timeline. It's more an opportunity to fix a mistake that was made in the past under the provisions of the code section that apply here. And so I would think that Ms. O'Day's writings on the collateral attack piece probably go into that more detail than I can now. But I think the short answer is that your concerns, I think, are spelled out in the code section and the criteria that apply to this sort of approval. It's not a situation where we're really arguing about whether or not an appeal timeline has run or not.
Okay, thank you.
Thank you. Anything to add, Ms. Eichner?
I would just add that the comprehensive plan itself has specific provisions in there to allow it to be modified through a certain process, and then Lane Code Chapter 16 has certain provisions that allow it to be modified as well.
Is this being done under this modification provision?
Yes.
Yeah, okay, thank you.
Thank you. The public hearing is still open. Further questions or comments from the board? I see none. Then at this point, I will close the public hearing. Now, discussion or deliberation by the board. Any questions or comments before we move forward with the recommendation? Commissioner Lycan.
Thank you, Mr. Chair. And so I would fully agree about keeping the record open. I think it would make sense to make sure that we had written comment back from Ms. O'Day on this particular piece in response to the information that has been brought forth by Land Watch. And so Did you say a week is enough for you? Okay. All right. That's really on my only comment now. And I think once we get that back, then I think we can, from my perspective, I think it's important to make sure we receive all of that before making some sort of final decision here. So, but if a week is good, then that makes sense to me. That's what all I have, Mr. Chair.
So a week from today is October 3rd. Commissioner Bozevich.
Thank you. So I just want to check in with staff. We hold the record open to 4 p.m. on October 3rd, and then response to any new materials for another 7 days, and then do applicant rebuttal for another 7 days. That would get us out to October 17th, and then we're down the 24th, so we're looking at the 31st for a third reading.
I don't know if I could meet my packet deadlines if we came back on the 31st.
Even with the 17th being the applicant's rebuttal, is that too close?
For Public Works, my packet would be due on the 16th.
Ah, okay. So we'd have to go into November with the third reading. So on the rebuttals or all of it? Yeah.
Commissioner, I'm not sure exactly how those ways in your brain, but typically in a quasi-judicial action, which this is, if any party requests the record be left open for any purposes, the minimum time is 7 days for that.
That's what I thought.
And then there's a week for addressing new evidence that's come in during that 7 days, and then a final 7 days for the applicant to have the last word. Shortening those things up, I suppose we can do as long as everybody agrees to it, but it's, we haven't done that before, and so
Yeah.
I leave that to your discretion.
Yeah, that's why I was going through that list and checking on the time and all that. So we'd be looking at the November 7th, it looks like, for a third reading and deliberations.
I see nods from staff.
Yeah, that's what yes, that would work for staff.
In terms of the timeline, the only question in my brain is the only person that's requested the record be left open is the applicant, who normally is in the position to respond last. But as I say, normally if any request is made, the board has gone through this 3-week process.
It's the safe, the safe harbor adoption of a timeline. So to prevent any issues in appeal about monkeying with those timelines, that my preference would be to stay with the quote safe harbor times.
Okay. Then do you have a motion ready to go?
Yes, I do. So I'd like to move first. You already closed the hearing, so I'd like to move approval of the second reading, holding the record open for 7 days until 4 p.m. on October 3rd, and then allowing response to any new materials until 4 p.m. on October 10th, another 7 days, and then allowing for the applicant's rebuttal another 7 days to 4 p.m. on October 17th, and holding a third reading and deliberations on November 7th.
Does it need to be 1:30?
Of ordinance, and that's of ordinance
Yeah.
PA 1355.
Could we do a 1:30 time certain, please?
On the 7th.
On the November 7th.
We can, it's not necessary because it's not a public hearing, but
Oh, that's true.
yeah.
I take that
Yeah,
back.
we've closed the public hearing, so I don't think we need a time certain. So just I want to make sure that it's clear that's for ordinance number PA 1355.
Coming back on the 7th for third reading and potential deliberation and final decision with no time certain.
And I'll second that.
Moved by Commissioner Bozevich, seconded by Commissioner Lack, and I will not reread the motion other than the final date is November 7th for the third reading, and it will be in the afternoon, but no time certain. Very good. Moved and seconded. Discussion to the motion. I see none, then I'll call for the vote. All those in favor, please say aye.
Aye.
Passes unanimously. Thank you, Ms. Wagner. We'll now move along to 1356. PA 1356, the second reading and public hearing on ordinance number PA 1356. In the matter of amending the Rural Comprehensive Plan to redesignate land from Forest Land F to Non-Resource Land NR, to rezone land from impacted forest land F2 to rural residential land RR10 NRES, and adopting savings and severability clauses, file 1509 PA 16-05041, applicant Sproul. Now, the explanation of the and purpose of the public hearing. This will be a public hearing. The decision is public. This decision is public to plan amendment and other criteria cited in the agenda cover memo and attachments. And evidence and testimony must be directed toward the approval criteria. And failure to raise an issue to enable a response may preclude appeal to LUBA. This is the opportunity for those present to enter information into the record. The only persons who qualify as party may appeal the board's. Only persons who qualify as party may appeal the board decision to LUBA. At this point, I will call for disclosure of board member ex parte contacts and for abstentions due to conflict of interest, ex parte contacts, or biases. Commissioner Sorensen.
I have none.
Commissioner Bozovich.
None.
Commissioner Williams.
None.
Commissioner Lycan.
None.
And I have none. We have no ex parte contacts or biases. Then at this point, Ms. Eichner, I'll hear the report. Thank you. It's much easier the second time through.
Yes. Chair, Commissioners, before you today, again, is an applicant-initiated request for a minor plan amendment with concurrent zone change. The subject property is known as Assessor's Map 160334, Tax Lot 102, and then a portion of Tax Lot 111. It's located east of the city of Coburg on the north side of Van Dyne Road. This review is commonly called a non-resource plan amendment zone change application. And we don't do a lot of them, but in recent years, we've done probably about 15, but we haven't seen one since 2004, besides one other application that's going to be coming to you next month. So this will be a good refresher for that. The theory with non-resource designations is that the soils are so poor in quality that it does not meet the state definition of either agricultural land or forest land. In order to qualify for a non-resource designation, the agricultural capability class of the majority of the parcel or tract has to be in a class 5 through 8 soils and have an average forest capability rating of below 50 cubic feet per acre per year. Should the plan amendment obtain approval, the applicant could theoretically divide the property into 3 lots, 2 vacant lots and 1 lot containing the existing dwelling. The subdivision is not part of this review and would be a subsequent land use application with opportunity to notice and comment should the application obtain approval. And prior to that subdivision application, we would also review legal lot status. The subject properties are, in fact, have a majority of class 5 through 8 soils and have a majority of a forest capability rating of less than 50 cubic feet per acre per year. The application, you can see on the map up on the wall, the neighboring properties. This whole area has gone through a number of non-resource plan amendments over the years. There was a small area of F2 zoned property left. The property owners that have applied are requesting this similar designation as their neighbors. You can also see there is a road that goes on the west side of the property. It's hard to see, but there is a traveled lane there and then exclusive farm use zone land. So the staff agrees with the applicant that they have addressed the OAR provisions and other criteria that are found within the packet. And staff would like to point out 2 typos in the findings and request changes be made to the findings before a decision is made. The first one is on page 7 of the findings underneath the goal 2 finding in the second paragraph down. There's a sentence that needs to be stricken that states the application is simply trading one resource designation for another because the land fits one category but based on use and capability. And that does not apply from going from forest land to non-resource rural residential. On page 9 in the second paragraph under the OAR 660-033-020-1A findings, there's a reference to the DAY report, and it actually should reference the RAB report, which is the soils analysis. Based on the information in the record, staff recommends option 1 with the said changes approving ordinance PA 1356. And I believe that there were additional comments entered into the record today on this item. And I will place them into the record as soon as possible.
Thank you, Ms. Eigner.
Thank you.
Before I open the public hearing, any questions or comments from the board? I see none. Then I'll be opening the public hearing, at which point we will hear the applicant's testimony, followed by testimony of persons in favor, testimony of other persons, and then additional comments by staff, followed by applicant rebuttal. I'll open the public hearing. Ms. O'Day. For the record, please identify yourself. And
Kim O'Day, Law Office of Bill Close, 375 West 4th, 97401. Good afternoon, Commissioners. Again, this application is a plan change, zone change. The map in your packet that follows the staff report will show you that this property is surrounded by other rural residential land. Across Van Dyne Road to the south is Cloud 9. To the north and to the west is the Van Dyne subdivision that the Stevensons did 10 years ago now. And the piece I want to point out is actually that left property that we're rezoning is actually split zone. So it is part of that property to the north. It is tax lot 111. Tax lot 111 is split zone, partially rural residential, partially F2 right now. We're going to correct that by making it all rural residential, plus the neighboring property to the west, which would be in a C then of rural residential property. There is a roadway to the east, and so this property is separated from any agricultural lands by a roadway itself. And so it basically is kind of what's left after a quite a few other plan change, zone changes that made things rural residential out there. It's all rocks. We're on a hill. And the property is neither forest land nor farmland, and so we're just asking for a zone change based on that. Thank you, staff. This one was a tough one. There's a lot of work involved by everybody. I appreciate staff's help and a great staff report, and I really, I'm just going to step back and let her take all the glory in this one because it was fantastic. Just this morning at 10:30 this morning, I received this much information. And plus a memorandum objecting to this application. And so obviously I could not absorb this. I would have loved to absorb this prior to coming to this hearing today, but I could not. And so once again, I'm stuck in a position of asking that the record be left open so that we have some time to look at the memorandum and figure out what these 3 inches worth of material actually mean, so that you have a full amount of information in front of you to make a decision.
And I'll presume 7 days should be adequate.
That will be adequate. I'm hoping that there's nothing here I haven't seen, so there'll be no new evidence, and I can just skip right to final rebuttal, I suspect, but we'll see.
Very good. Thank you, Ms. O'Day. A testimony of any persons in favor. I see none listed. We'll move to item C, which is testimony of other persons. Today we have one person signed up, which is Sean Malone. Mr. Malone, please step to the mic. You'll have 3 minutes, at which point I will grant you some latitude to complete your sentence or thought.
Okay, the first real big
Please identify yourself for the record.
Sorry, I thought, since you said my name. Sean Malone on behalf of Landwatch Lane County. I think the first issue here we got to clarify is what kind of zone are we actually seeking here? The applicant has decided to, is alleging going to rural residential NRES. Now, if you go to Chapter 16, you won't find that zone for rural residential. There's only two types. One is rural residential, the other one's rural residential, rural comprehensive plan, RR, RCP, and RR. So those two zones allow for different types of uses. So we need to clarify which one of those we're talking about, whether it's 16231, which is rural residential RCP, or 16290, which is just rural residential. They're requesting rural residential NRES. That doesn't exist. So that easily has to be clarified. With regard to the suitability of the soils, what agricultural class is, the board's essentially left with a policy choice. The Soil Conservation Service and NRCS identified these soils as overwhelmingly Class 4 soils, which makes it de facto agricultural land. The applicant has hired a consultant to tell you that the soils are less suitable than that. So there's substantial evidence that exists both ways on this one. And it comes down to the policy choice of the board to get rid of more resource land in Lane County or retain more resource land in Lane County. Moving along here, the applicant's required to demonstrate satisfaction of various standards related to whether a property is agricultural or not, apart from the issue of soils. There is a host of information here that demonstrates that past farm uses have occurred on these properties. Farm use includes, it's very broadly worded. It includes harvesting, selling of crops, feeding, breeding, management, and sale of livestock, poultry, and honeybees, dairying, and the sale of dairy products, animal husbandry, stabling, and training of equines. Now it's the affirmative obligation of the applicant to demonstrate that none of those farm uses are possible on this property. And take a look at the record here. The applicant hasn't even attempted to address those. So outright, this application is pretty deficient in that regard. When we look at suitability for grazing and other crops, tax lot 111, that was pointed out by Ms. O'Day, has a permitted agricultural building of 1,488 square feet. It's currently receiving farm deferral. That is, they're telling you this property is not agricultural, yet the applicant is receiving the benefit of alleging that it is agricultural. Set forth more things in here with regard to availability of water. The applicant has entirely omitted the fact that there's a pond on the property, so irrigation is very possible, and as well as pond for livestock and so forth. And probably one of the bigger points, if I could get that map, the initial zoning map, can we put it back up there? There's this allegation, this notion that this property is just surrounded by rural residential property. But all you have to do is step back a little bit, and I put that map in the record. And to the left, you have exclusive farm use. And essentially what it is, that rural residential area right there, that's essentially the middle of a donut. And completely surrounding that area is all resource land. This skews what you're actually seeing, because you're not seeing the whole picture. And surrounding this entire area is resource land. And so the notion that it is, as the application says, or the findings say, it's swimming in residential, rural residential areas is just plain wrong. The existing land use patterns here are overwhelmingly resource, and that in and of itself demonstrates that this land is agricultural. Again, a host of accepted farm practices that are that have not been demonstrated, that cannot occur on the property. And if I could point out one that's more recent to us all here in Oregon is the cultivation of marijuana. It doesn't require soils, particular soils, because everyone's growing this stuff using supplementary soils and nutrients. The people that are submitting these applications, none of them are my clients, but I've seen these applications, and they're using them in potted large pots, cloth pots. So the soils issue really doesn't come into whether they could engage in a farm use related to marijuana production. And
Thank
again,
you, Mr. Malone.
yeah, I'm way over. I know it's difficult
That's all right.
to get.
You had the latitude.
So there is more in there, and I encourage you to read it.
Thank you. Very well, then that concludes the people who have signed up for the public hearing. Anyone else anyone else other than in favor wish to provide testimony? I see none. Then Ms. Eichner, additional comments?
The only comment that I really have is the zoning that will apply to this property would be Lane Code 16231. The very last finding in the findings document attached to the ordinance does make that statement. But I do agree in the beginning of Lane Code Chapter 16, there is not something that says RR-NRES. That is the 16231 of Lane Code is what we use for all the non-resource rural residential properties.
Very good. Any questions or comments from Ms. Eichner before we move along? Then Ms. O'Day, we have applicant rebuttal. No, I see no applicant rebuttal. Then at this point, I will close.
Oh, Mr. Chair.
Oh,
I just wanted to ask a question on the remaining process. So there's been a request to leave the record open for 1 week. What happens now on the remainder of this matter?
Depends on the motion we approve.
I'm presuming we'll be moving forward with a similar motion, which is the dates, the October 3rd, the 10th, the 17th, and November 7th. So,
Okay, thank you.
Oh, that works.
very good. Further discussion, questions? Then I will close the public hearing and open the floor to discussion and deliberation by the board. Any questions or comments?
So,
I see none. Commissioner Bozievich.
so one quick question for staff. Farm deferral, is that a zoning designation or a tax designation?
That is something the tax assessor grants or not, based on applications made to the tax.
Can you get a farm deferral on an RR piece of property?
I do not know. I would suspect so. I think it has to do with the use of the property rather than its
Yes.
designation.
Thank you.
Yes, you can.
Just wanted to clarify that for my own thoughts.
Thank you. That's, I see no further discussion. Commissioner Bozievich, do you have a motion?
Yes, so I'd like to move approval of the second reading and holding the record open for 7 days to Tuesday, October 3rd, 4 p.m. For any new testimony, then response to any new testimony for 7 days to Tuesday, October 10th at 4 p.m., and then appellant's rebuttal to testimony until October 17th at 4 p.m., and setting the third reading and deliberations for November 7th for ordinance number PA 1356.
Second.
Moved by Commissioner Bozievich with the ultimate date of November 7th. Seconded by Commissioner Lycan. Discussion to the motion. I see no discussion to the motion. I'll call for the vote. All those in favor, please say aye.
Aye.
Passes unanimously. Thank you. Thank you, Ms. Eichner.
Thank you, commissioners.
I think we're going to see you again before the day's over, so. Very well. Then we'll move along to order number 170926-06 in the matter of hearing arguments on the record of an appeal of a hearings officer affirmed decision denying a forest template dwelling in the impacted forest land zone F2, assessors map 160227, tax lot 1506. And today we have Mr. Rickoff, we have Amber Bell. Ms. Bell.
Thank you, Chair. Good afternoon, Commissioners. Today, the Board is asked to hear arguments on the record for an appeal of a hearings official decision to deny a forest template dwelling in the impacted forest land zone. This is the Wolcott template dwelling application, file number PA 155770, that the Board elected to hear after finding issues raised on appeal could be of countywide significance and or reoccur with frequency, and that was at the August 22nd meeting, as you may recall. To summarize a little bit of the application history, the application was denied by the planning director, and the denial was then affirmed by the hearings official. And in short, the reason for denial was that the subject property is not a final legal lot. While there was a 2003 preliminary legal lot verification that was completed for the subject property, it has not yet been noticed pursuant to Lane Code 13020. While often applicants will or can request notice of legal lot concurrent with the template dwelling application, in this case, the preliminary legal lot determination appeared to be inconsistent with the Redco v. Polk County case. Additional arguments by parties today must be confined to the record that was before the hearings official. The procedures for an on-the-record hearing are specified by Lane Code 14.400, and the criteria for a template dwelling decision are found at Lane Code 16.211.5 and 8. The persons who may participate today in the on-the-record hearing are the applicant, Josh Peterson, the owner and appellant, James and Nancy Wolcott, their agent representatives, attorney Michael Farthing, Tom Lanphier, and Rolly Keeney, and other parties of record, William Enos, Landwatch Lane County, Robert Emmons, and attorney Sean Malone. Before I summarize staff's analysis, I'd like to note that Michael Farthing and Sean Malone have submitted letters to the board with additional arguments on the record. I provided a copy of those to you, and there are also copies available at the back of the room. In terms of the appeal issues and staff's analysis, the appellant asserts that the particular factual circumstances of the creation of the subject property are distinct from that in the Redco, Van Belduzen, and Koo cases, and that Redco applied to the elimination of subdivision lot lines and should not be applied in a more broad manner. To understand the issues raised on appeal, I'd like to provide some background information about the subject property creation. In 1919, a large piece of property located north and south of what is now McGowan Creek Road was conveyed, and bisecting that property was a 40-foot wide logging road. And then in 1960, that area, additional land in the logging road was conveyed to common ownership. Then in 1984, minor partition M115984 was approved and recorded, dividing this land into parcel 1 and parcel 2, and the partition map did not depict the logging road. Here's an image of that partition map. And then subsequently, in 2001, 3 preliminary legal lot verifications were issued for parcel 2. And these identified an abandoned logging road, and then areas to the north and south of the abandoned logging road. And then in 2003, these areas within parcel 2 were subject to property line adjustment. A second round of preliminary legal lot verifications were then completed, but unfortunately at that time, Lane Code did not require public notice. And then fast forward to 2017, during the proceedings of this land use application, the property to the north of the subject property was recorded as a validation of unit of land parcel. The Redco v. Polk County case found that a partition plat that creates a new parcel without depicting any nested lot lines has the effect of vacating the pre-existing lots, where there's nothing on the partition plat description or narrative that suggests an intent to preserve the existing lots. I'll just go back to that 1984 partition there. If it were possible to retain nested lots within a partition parcel, the 1984 partition did not do so in this case. Furthermore, the Court of Appeals decision on Redco stated it is also difficult to imagine that the legislature intended the previous lot lines to survive such a process, creating a spider web of overlapping lots and parcels, suggesting that Redco applies in a more general manner than the specific circumstances suggested by the appellant. While there are some distinctions between case law and the subject property creation, and that Redco involved a 1983 partition over a 1911 subdivision, and this is a partition over underlying deeds. The general logic of Redco appears to apply, and for these reasons, the 2001 and 2003 preliminary legal lot verification determinations recognizing the existing of the abandoned logging road appear to be inconsistent with ORS 92. Second, the appellant asserts that the ambiguities of the legal lot determination form were not fully addressed in the hearing's official decision, and that the county's preliminary legal lot form relied upon in 2001 and 2003 provided assurances that have now been reversed. This is certainly an unfortunate reality that Glencoe did not require public notice at that time. With regards to this issue, the hearings official's June 27th, 2017 decision describes that the last paragraph of the legal lot verification form states that it was a preliminary decision of legal lot status. This disclaimer represents the same process that was evaluated by LUBA in the Davis v. Lane County decision from 1997, and that determined that the county did not have a process for making legal lot determinations binding, and in dicta seemed to agree that with the county that the legal lot verification process was not even a land use decision. And therefore, staff finds that this issue has been adequately addressed by the hearings official. Finally, the appellant asserts that the hearings official erred in his conclusion that the validation of unit of land plat to the north did not have the effect of verifying as a legal lot adjacent remnants. And that the hearings official and planning director's interpretations are inconsistent, because while the hearings official indicates that the validation of unit of land process in ORS 92-176 is a sole remedy for recognition of an unlawfully created parcel, the county has in the past recognized these types of remnants through the legal lot verification application. The hearings official's affirmed decision further confirms that the statutory validation of unit of land process under ORS 92-176 is the sole remedy for a legal creation of a property, and should be used for that purpose in this case. The applicant has provided one example of where the county processed a legal lot verification application for a remnant parcel that was adjacent to a validation of unit of land property. However, if that was incorrect, that would not be binding upon the county. Also, issues pertaining to ORS 92-176 requirements are a matter of statutory interpretation for which the county would not have deference if this application is ultimately appealed to the Land Use Board of Appeals, and staff do believe that this application, whether it's approved or denied, ultimately will be appealed to LUBA. And if so, then that would provide clarity on statute. It's important to ensure that state law is applied correctly. It appears that in this case, the hearings official decision is consistent with ORS 92. In conclusion, staff find that the hearings official's decision addresses appeal issues adequately and is inconsistent with ORS 92 and the Redco case, and this was the basis that informed the fact that the preliminary legal lot verification was not noticed, but the criteria that was not met in the template dwelling, again, is that it's not a final legal lot. The subject property is not a final legal lot. And unfortunately, unless new case law determines otherwise, Redco must be applied as a matter of law. Therefore, staff recommend that the board affirm and adopt the Lane County hearings official affirmed decision as the county's final decision and expressly agree with and adopt interpretations made by the hearings official. That's option one. The board's decision will be the final county decision, and parties will have the opportunity to appeal the application to LUBA pursuant to ORS 197. That concludes my presentation.
Thank you, Ms. Bell. So just for clarification for my own information, plus anyone who maybe have the same question online, you're suggesting that whatever action the board takes today, the likelihood is that this will go to LUBA. It will be appealed to LUBA.
Staff believe that it's likely.
It's likely, and it's just so the two of the three options actually says we have option one, option two, or option two. I think it probably means option three. Yeah. So if we go with 103, it just determines who will be actually making the appeal to LUBA, whether it's the applicant or the appellant. Now, a question for my own information, once again, is the financial burden of such an appeal to LUBA. Is there a financial burden borne by whoever makes the appeal to LUBA?
Maybe a question that our legal counsel could answer.
Well, yes, there is. I can't remember, frankly, what the appeal fee is since we don't file many. But it is largely subsumed by the legal fees associated with it. So in reality, who files the appeal isn't the great expense. It's
So safe for me to consider it negligible then?
I think so.
Okay. I'm looking around the room to see if anybody's shaking their head about that.
Yeah, the appellant's attorney will provide information otherwise.
Once again, that was for my information and not for any decision making. So. And we do have the two letters that you mentioned, one from Mr. Farthing, one from Mr. Malone. Discussion by the board. I'm seeing no discussion at this point. This is hearing arguments on record. Can you explain that just a little bit?
Yes, so this affords parties that have participated in the proceedings before the hearings official the opportunity to provide additional arguments. So first would be the appellant and applicant. They can provide arguments on the record that was before the hearings official, and then other parties, Landwatch, Robert Emmons, Sean Malone, or William Enos, and then that would be followed by additional comments by staff, followed by the applicant, appellant's rebuttal. And I will note that the applicant and appellant are one and the same in this application.
Very good. So I'll follow this script and open a public hearing. Okay.
Yeah, that would be great, starting at 1.
Very good.
Or 2.
And,
Not a public hearing, though, right?
It's a hearing on the record.
Yeah, if I can clarify, yeah,
Please.
it is a public hearing, but it is limited to argument based on evidence that's already in the record, correct?
Okay. So,
And one thing I'll pass on, just for maybe the board to consider as being convenient, is because Ms. Bell has identified a number of people who are parties, the board may want to discuss time limits for particular testimony. A lot of times we've had hearings where the applicant takes kind of as much time as they need. The opponents sometimes get caught off at 3 minutes, and there's discussion about that and whether that's fair. It came up, for example, in the hearing on the Hazeldale matter up in Oak Ridge, where we had a lot of people to testify and a lot of discussion about can we consolidate time among the people who are appearing on various sides. So the board may want to consider some of that.
okay. And I have no sign-up sheet, so there's no sign-up sheet. It's just the.
Chair Farr, that is correct.
Very good. Then, so pardon my confusion. We have an ordinance following this, and I have a script here, which I was presuming for the ordinance following this. The script that I have, is that for the particular the board order that we're going through right now?
Hopefully, there's one that has Walcott at the top. Is that the script?
Very good. Thank you.
And then paragraph number 2 contains the
Got it. Thank you very much. Okay.
information the board needs to provide.
All right.
I think Chair Farr, if you could,
I do have that. Thank you.
and if you could read the items under 2.
I do. Okay, then the purpose of this hearing is to hear arguments on the record that was before the hearings official for file number 509 PA 1505770, a hearings official denial of a forest template dwelling application. This decision is subject to the template dwelling criteria at Lane Code 16.215 and 8, and the procedures for an item on the record hearing are found at Lane Code 14.400. This hearing is on the record from the hearing of the hearings official, and only the persons identified in LC 14-604 will be allowed to participate in the on-the-record hearing. Issues discussed will be limited to those raised in the appeal, and arguments must be directed toward the approval criteria. Failure to raise an issue to enable a response may preclude an appeal to LUBA. Only persons who qualify as party may appeal to the board's decision to LUBA. At this point, I will call for disclosure of ex parte contacts or abstentions due to conflict of interest, ex parte contacts or biases. Commissioner Sorensen.
I have none.
Commissioner Bozievich.
I have none.
Commissioner Williams.
I have none.
Commissioner Lycan.
I have none.
And I have none. There are no ex parte contacts or biases. We've heard the report by staff. At this point, I will open the public hearing. And we will first hear the applicant's arguments. Mr. Farthing. Please state your name and address for the record. Thank you.
Thank you, Chair
And then, Mr. Farthing, we will restrict this to 3 minutes per now,
It's a little tight.
That is, I think, up to the board's discretion. Our current code doesn't provide exact timelines for these sorts of appeals. I would suggest that 3 minutes is not going to be enough for Mr. Farthing to cover a rather complicated legal.
Then I am open to Commissioner Sorensen, please.
Yeah, I was going to say, I think it would be good to hear from the lawyers that are going to argue this on what would be a fair thing, and then we can make a decision after we hear from them, because I agree that 3 minutes is insufficient for the applicant, and I agree it's insufficient for the opposition.
Very good. Then, Mr. Farthing, you will not be on a clock.
Well, if I could also add, as by way of introduction, I think we're 5 minutes apiece, uncharacteristically brief.
Very good.
I've got the 1.5 foot of record that Ms. Bell has right down here, too.
Very good.
Again, Chair Farr, Commissioners, Michael Farthing. I represent Ms. Keeney, the original, the purchaser of the created lot in 2003, the Walcotts and Petersons who are trying to build a house on it pursuant to the template dwelling provisions. Thank you for electing to hear our arguments on our appeal of the hearings official decision. Please ask questions if you have them. This is a complicated matter, even though the issue is very simple. Was tax lot 1506 lawfully created? That's it. Was it lawfully created? And that's what a 1.5 foot of record has produced. We have made 3 separate arguments on this to overturn the hearings official, and in doing so, your staff recommendation. We realize we have a big burden to do. We believe the Redco case has been misapplied by the staff and by the hearings official. We believe the staff and hearings official have misinterpreted the 2003 legal lot verification form, which is just one of many that occurred back in 2001 to 2003. There were numerous legal lot verifications, and there were numerous property line adjustments as outlined by Ms. Bell on the map changes that occurred in that time period. And finally, we believe there's been a misapplication of ORS 92-176, which involves the validation of unit of land. Fairly new provision, I think 2007 came into effect. Provisions have now been added to Chapter 13. We believe all 3 of these arguments that we have made, and I'd refer you to my August 1st letter that outlines in detail, but it goes, the record before the hearings official is very detailed. There's lots of information, lots of history, stretching back to a century, back to 1919. There's documents, different codes, all sorts of things that influence this decision. Again, we believe all 3 of our arguments provide separate reasons to overturn the hearings official. However, the recent partition for tax lot 1508, which is the middle parcel there of parcel 2, provides the simplest and most defensible action on the part of the county to grant the status of lawfully created. For this, I want to introduce Mr. Lanfear, who, unlike me, will address the effect of the recent validation for unit of land in a very concise manner. Thank you.
Thank you. Ms. Lanfear, once again, please state your name for the record.
Good afternoon, Commissioners. My name is Tom Lanfear. I'm at 541 Willamette, Suite 402, Eugene, 97402. Appreciate the opportunity to speak to you today. The staff report is very detailed. It's hard to track all of the detailed information that came in the record, and staff's done a great job at that. Unfortunately, we disagree with the conclusion, but there's a lot of hard work in there. There's no dispute that this application meets the template requirements except for one criterion, and that criterion is the lot or parcel which the dwelling will be located was lawfully created. That's what this whole stack of paper is pretty much about. A brief chronology of what's happened. Amber's has a nice chronology up on the screen for you. In 1919, you could create parcels by writing a description, meets and bounds. In 1984, there was a land division of the property that included all the parcels in their common ownership. And a map was created that showed just 2 parcels. Where there were numerous meets and bounds description parcels, it just showed the 2 parcels, as you see on the map there on the board, on the screen. Subsequent to this, the legislature took action and adopted a provision in ORS that said a discrete parcel remains a discrete parcel unless it's further divided by law or vacated. In 2001, there was a couple of legal odd verifications that recognized the old parcels as discrete parcels. And in 2003, those parcels were adjusted by property line adjustment and again verified to be lawful parcels. And then in 2011, we have the Red Code decision, which said, well, no, the 1984 partition wiped out the old meets and bounds parcels and affected the ownership underneath. Okay. What the question you need to ask is, does a partition divide land? That's what this is all about. Although the staff has identified REDCO as applying in this situation, and we don't think it does, what you're left with that determination made by the planning director and the hearings official is that parcel 2 on this map is the last lawfully created parcel that they recognize. Okay, that's what we're starting with. Now it's 3 tax lots. In 2007, the legislature enacted a process that allows validation of a unit of land that was not lawfully created. The middle tax, if I could see the tax lot map. Yeah, the middle parcel there, this one, came into the county and used that ORS provision and was granted approval to validate that as a unit of land. You'll see that that is the middle section of the original parcel that the last time it was lawfully recognized as a parcel. The statute requires a partition plat to be recorded. It explicitly says partition plat within 90 days of the decision, and that was done, and that's reflected there by these numbers showing there's a plat boundary around that parcel. So the applicant had, the owner of that parcel had to record a partition plat. So what's a partition plat and what does it do? A partition plat is a final map concerning a partition. A partition means the act of partitioning land, and partitioning land means the division of land. So this plat filed on top of the old original partition plat actually divided this land into 3 pieces. Staff has recognized that this is what occurs since 2008 when this ORS provision came into effect. And they've been acting accordingly all these years. And as most recently as 2015, they verified that a remnant, as you call a remnant property, was a legal lot based on the recording of a validation plat. So it's been staff's practice since 2008 to recognize this action, and yet in this application we're changing that and saying it doesn't do that. It's not really fair to this applicant. It's a reasonable interpretation of state law because you are saying that a partition plat divides land. That's not an extreme position to take. There may be a lot of argument up at LUBA about the effects of these validation plats, but I think it's reasonable for the county to take that position and stay consistent with what's been happening with the planning director since 2008. Available for questions if you have any.
Thank you. Questions or comments from the board? I see none at this point in time. Then other parties.
I just have a couple more comments to make. Michael Farthing again. I don't know if I gave my address, P.O. Box 10126, Eugene, Oregon 97440. I couldn't say it more succinctly than Mr. Lanfear. I want to provide just a little bit of context for the people who are here, especially Ms. Keeney. Tax lot 1506, as you see it up there, the parcel in question, was lawfully created in 2003. We did, and I say we because I was on the application. My name's, I was representing Archie Williams, son of Myrtle, at the time, and I think they started with other people, but they ended up with me in 2003. I was working with Don Nickel at the county to do all this. If you look at and attached to my August 1st letter is the legal lot verification form. Michael Farthing, applicant, agent. We did everything we were supposed to do at that time. As staff indicated, there was no requirement for notice. It was a legal lot at that time. Well, what did that mean? And I've referenced this in my materials, but I just want to read this to you. This is from the approval, written out by Don Nickel. I recognize his printing. Based upon the findings provided in this report, the above referenced property, tax lot 1506, constitutes a legal lot, which means, one, ownership to this property may be conveyed with the assurance that such a conveyance would not require approval by Lane County Land Division regulations, and two, Lane County recognizes this property as a legally separate unit of land for the purposes of development. Development would still be subject to applicable zoning, sanitation, access, and building regulations. What the staff and Mr. Darnielle are saying is the, oh, by the way paragraph at the end on the second page in different type, smaller type, which says this is a preliminary indication in the above referenced property, means that it doesn't count. Even though at the time, it's all that Lane County offered. We paid a fee for this. You said it was a legal lot. You gave us assurance that we could convey it, and it was conveyed. The one next to it, 1508, received the same assurance. It was conveyed to the Stennets. They applied for a building permit, and boom, 13, 14 years later, they get a validation of a unit of land. Ms. Keeney just held on to the property and didn't do anything. That's the difference in this whole thing. I get a little charged up, but I was involved in this. And again, I felt like I did everything possible to put it in Ms. Keeney's name. And what do you think she's going to do when she reads this? What would a reasonable person think? It's a legal lot. I can sell it. I can apply for stuff. Anyway, I won't repeat what Mr. Lanfear said about a partition. A partition is a partition. It divides land into 2 or 3 parcels. Subdivision divides land into 4 or more lots. That's been the classic distinction. And the county policy recognized since 2007, 2008 that the lawful remnant, if there was a remnant, was a legal lot. And then out of the blue, the hearings official comes up with a rationale that I don't think is very persuasive. It's on page 6 of his June decision, if you want to read it at the bottom. He doesn't cite anything. He doesn't provide anything. I looked at the legislative history of 92-176. It's inconsequential. There's nothing mentioning remnant parcels. And I think most likely, probably, assuredly, it's because the legislature didn't think about it. These things happen out here in the trenches. And now the staff wants to change its policy based on the hearings official's decision. I don't think that's a good idea. I don't think that's good government. I think Ms. Keeney had an expectation. She had an assurance back in 2003. I think there are legal reasons, as Mr. Lanfear outlined, why you can find that this parcel, tax lot 1506, was lawfully created, and you can direct staff, and I will certainly offer to prepare findings to reflect that decision in a revised or modified order. If you have any questions, please let me know, or Mr. Lanfear.
Thank you, Ms. Farthing. Questions or comments? Then we'll proceed. Other parties, arguments. We have Landwatch Robert Emmons, Sean Malone, or William Enos. Please step forward, state your name and address for the record.
My name is William Enos, 36326 Shara Lane, tax lot 106 on this map. My objections are much of the same as they were in a previous hearing, even more so though today, and that being that this being a heavily timbered area and my lot being on the end of a private lane, very concerned about fire in this area. Other concern is water, and that being I have a new neighbor in the lot number 119 who just borders my property, just built a house. There was a well placed in there 2 years ago. He just built the house. They moved in the 1st of June. The well went dry the 1st of August, 2 months later. My water is, I've been there 12 years, is going down. My quality is, I was changing filters when I first moved in 12 years ago, every 2 months, 2.5 months. And today, I'm lucky if I get 3 weeks out. I have to change the filter. We're at the bottom. I'm in the process of getting estimates to redig my well, make it deeper to obtain water. The water table is going down quick. And just adding on, we've had properties added on recently, and it's draining the water table. I'm very concerned about this. Thank you for your time and listening to what I had to say.
Thank you, Mr. Enos. Any further other parties? Landwatch Robert Emmons or Sean Malone? Mr. Malone? Please, once again, state your name for the record.
Thank you, Sean Malone, on behalf of Landwatch Lane County. Just to piggyback on the most recent testimony, this is F2 land. Minimum acreage size should be 80 acres. So when it becomes parcelized to a significant degree, as it has in this around this area as well as elsewhere in the county, you're going to have water problems. And that's one of the problems when you start to parcelize all this resource land. And so I have a great deal of sympathy for Mr. Enos, because what will happen as a result of this application, if it were to be overturned and then upheld, which I think is extremely unlikely, is that you just have more parcelization of resource land and you'd have more constituents with water problems out there. But to go into the issues at hand, I think Ms. Bell's done a wonderful job of summarizing these 3 issues and explaining them. Currently we have the planning director, we have staff, we have the hearings official, all disagreeing with the applicant, and for very good reason. The first issue is this Redco decision. Now, just to break that down real quick, if you have a piece of property and you have nested lots inside that, when you subsequently go to get a approval for a partition, those underlying lots, the lines, are vacated because you're putting new parcels on there. Now, the Court of Appeals saw the wisdom in that and understood that if you just put a partition over the existing lines, you would end up with a spider web, as the Court of Appeals used the term, of interlocking lots and parcels, and it would be impossible to deal with regard to land use. It would be unworkable. And that's one of the primary justifications for the Redco decision. You don't just keep piling things on top of each other. When you seek a partition, you vacate the things underneath that. If you want to keep the things underneath that, don't go for the partition. So the Redco decision is very straightforward, essentially. And the only distinction being drawn here by Mr. Farthing is that in Redco, it was a subdivision that was the existing lots, and then a partition occurred over that. And here, it was just lots created by deed, and then a partition over that. It doesn't matter whether it's a subdivision or lots created by deed. The partition has the effect of vacating those under ORS 92017. It's all pretty straightforward, although it can deal with some confusing concepts. With regard to the legal lot verification issue, that's not what we should call it. We should call it a preliminary legal lot verification because that's what occurred. It was never it was never noticed at the time, and therefore it was never a land use decision. And Mr. Farthing is essentially just arguing against established LUBA case law in the Davis case that says more or less that those weren't land use decisions, and so there was no legal lot verification right given at that point in time. Again, the form that Mr. Farthing keeps referring to states, and I quote, "This is a preliminary indication that the above referenced property, as further designated on the enclosed map, is a legal lot. The decision that this property constitutes a legal lot will be made at the time of the first permit or application action where a legal lot is required." And that's because it would be noticed at that time. So again, just arguing first against Court of Appeals established case law, second arguing against established LUBA case law, and then third we go to this issue of validation of a unit of land. Now perhaps the most important thing to understand with regard to this is that the validation of unit of land application that Mr. Landfair was referring to is not the subject property. The hearings official said, if you want to remedy all this for the subject property, go get a validation of unit of land. That's the remedy here for Mr. Farthing and Mr. Farthing's client. To somehow argue that a validation of a unit of land on a separate property somehow affects a different property, it makes no sense. And the argument essentially being set forth is that the property that was not subject to the validation of unit of land is and I quote, a lawful remainder. The notion of remainders has been addressed by LUBA at various times, and they've acknowledged that that word, remainder, does not arise in ORS 92, ORS 197, ORS 215, and that this idea of a remainder it's nowhere to be found in the land use laws. So essentially, I can't understand how that argument would hold water at LUBA, and I think, again, staff, planning director, hearings official, they've all done a great job in this and pointing out the errors, and I would just request that you affirm the hearings official's decision. Thank you.
Thank you, Mr. Malone. Further testimony? I see none. Then we'll proceed. Additional comments by staff.
The only additional comment that I would have is I don't believe I provided an explanation as to what precisely ORS 92-176, the validation of unit of land process, is. That statute includes essentially two criteria, one being that there was a law or a approved building permit issued for the property. So in this case, tax lot 1508, there's a permitted dwelling on that subject property, and that is the basis under which they were able to obtain a validation of unit of land. And the other criteria that could be met is whether, if the property was not created lawfully, could it have met the applicable minimum water parcel size at the time. And so that's the test that it needs to be demonstrated for a validation of unit of land, and that otherwise the statute is silent on remnants. I have no other further comments at this time.
Okay, thank you. Then my script says we'll look for the applicant or appellant's rebuttal. Mr. Farthing.
Thank you. I'll start with the last thing that Mr. Malone said, that there's nothing in the statutes or the ordinances about remainder. Likewise, there's nothing about nested parcels that's been thrown, the same term being thrown around. These are simply things that are added on or are commented on by people, cases, judges, lawyers, as a way of explaining things. With regard to the Redco decision, two major differences between this and that one. In Redco, it was a platted subdivision, a 1911 subdivision, much like out by Alvador. We call them fruit farm subdivisions. And everybody knew about it. It was platted. It was of record. And then there was a 1983 partition over it. And nothing happened much after that. And the court said the effect of that partition was to vacate those fruit farm lot lines. And they said lot lines. Now, I made the argument that it doesn't apply to parcels and everything. The big difference is that this logging road that was the basis for these 3 lots up here wasn't known to anybody in 1984. It wasn't of record. It became of record 17 years later when it was finally recognized by Don Nickel when he was talking to Myrtle Williams and Archie Williams about what they could do with parcel 2 of that partition. In the initial recognition of legal lots, the logging road, it references parcel 2. And that's the big difference is the county was an active participant in recognizing these legal lots in 2001 and then again in 2003. Polk County denied the application for Weyerhaeuser. Polk County denied the application for Koo. Marion County denied the application for Van Velhuizen. They were fighting tooth and toenail with the applicant. That wasn't the case here. The county was an active participant in recognizing these lots 19 years after 1984. So now you have the 2011 case somehow sweeping in and telling Ms. Keeney she doesn't have a lot anymore. How does that work? I don't understand. Also, there was mention that the preliminary legal lot verification wasn't noticed. No, it wasn't noticed. It wasn't required. It was still a final decision in 2003 per lane code requirements. The Davis case was mentioned as somehow detracting from the form that was used. Davis involved a denial of a legal lot, a different form. It didn't have those county assurances that I read you. It was simply a denial, period. And that form was not in front of LUBA at the time. I do want to read that preliminary indication thing. Well, I don't have it here in front of me. The third sentence, which Mr. Malone did not read, and this is the preliminary indication, is that you only need to seek a legal lot verification if the boundaries have changed, which would suggest that if the boundaries haven't changed, you don't need a legal lot verification, and it was final at the time. The boundaries didn't change for tax lot 1506. Everybody kind of forgets that third sentence in there as qualifying. That's a way you can read that. I'm asking you, and this isn't our main argument, but I am asking you to interpret this form. How does this form work? Because we had like 3 of them in ours, or 6 of them. You can imagine how many were issued in a 10-year period that have that. And staff mentions that in the staff report. It's a very obvious and unfortunate ambiguity. Now, whether you distinguish that now, I'm not sure. I think that's all I have for now. I feel more confident than before. I think we have a very good way for you to find that this parcel, tax lot 1506, was lawfully created either through the partition process or it was created in 2003 and never lost its validity. And that's, in effect, what is happening here.
Thank you, Mr. Farthing.
Thank you.
Before I close the hearing, are there any questions or comments from the board?
Commissioner Chair.
Commissioner Ligon.
Thank you, Mr. Chair. So, question this may be for Andy. As I'm listening to the information being put forth, listening to, and I'm looking here from, in fact, it's in our packet. So, looking here from what Mr. Farthing was discussing from 2003. And so the arguments being put forth by the applicant, by those who are opposed, this is very subjective. I think this is subjective. So I need a question from you. I don't think does this fall under quasi-judicial? Because I have a hard time actually getting my arms around quasi-judicial based on information that's flowing in here like this. And so I just maybe like to get a response from you, because I've been in a lot of land use hearings, and quasi-judicial is pretty set forth based on absolute criteria. There's a lot of criteria floating around here from before to 2003 2011, and now where we are today. So does this fall under strict quasi-judicial?
It does, yes. Quasi-judicial just means in this case that it's relevant to a fairly discrete, isolated situation, a piece of property in this case.
Even the
And it
interpretations?
involves-
There's several interpretations that are coming here.
but don't confuse quasi-judicial with clear and objective. You can have clear and objective standards for something which means there's no discretionary interpretation by the planning director or the board. In this case, there's plenty of room for interpretation, and that's why we're here at this hearing, is for the board to interpret the relevant law that applies, be it both state and county. But yeah, it is quasi-judicial, but certainly not simple.
It is not a straightforward quasi-judicial that I've seen in my 19 years of public office. We'll put it that way. This one is basically all over the board, and that's why I wanted to make sure I got it from your perspective on this. Where we're in a sense what we're bound to.
Part of, and I'll just mention this, part of the staff's difficulty in wrestling with this is that it does involve those standards that need interpretation, but there's this sort of overarching equitable issues floating around, which is the applicant did what they thought they needed to do at the time. The problem with how the staff reacts to that is that the interpretation of what the law is has changed since actions or inactions were taken years ago, and the staff is stuck with the situation of trying to treat the applicant fairly, but also doing what the law requires. And in this case, the conclusion is that law requires an application of law that is harmful, frankly, to the applicant and their position.
Thank you.
Any further questions? Then, Commissioner Lycan said that this is subjective. It's pretty complicated in that we are receiving what seems to be conflicting information, and we have to make a decision based upon one of your three recommendations. But for me, Mr. Clark, you said the applicant did what they thought they were supposed to do X number of years ago. And I would read that as not what they thought they were supposed to do, but actually what they were supposed to do, based upon what was the law those years ago. So they did everything exactly correctly. And it's only subsequent to that that the interpretation of the law has changed, meaning making what they did according to the recommendation that staff is making and the hearings official making what they did previously invalid, which was legal and everything that they absolutely had to do by the law at the time. Am I correct in that?
Well, yeah, I think so. I mean, essentially, staff at the time was operating under the policy that they thought implemented correctly the state law.
Mm-hmm. And subsequent to that,
current interpretation is that was incorrect. And it's the same law being interpreted, just being interpreted differently by staff 10 or 15 years ago versus today. And the gloss on the interpretation is, in part, this Redco decision, which, in its most general understanding by me, is that underlying lot lines, and whether those lines were created by subdivision or by deed, which is how you could divide property before regulations about partition subdivisions, those lines on a map, if you do a partition and then record the partition plat map over the top of it, has the effect of vacating those underlying property lines. And so that's the law that staff is interpreting now. And I'll note my understanding legally of the partitioning process is you have partitioning, which is the county decision, yes, this meets the criteria, we can divide the land this way. And then the sort of, what's the word I want? A sort of ministerial act of recording that decision on a plat map and having it recorded. I think one divides property, the recording of the map essentially just memorializes the decision that was made, the division of the property. So that applies to one of the arguments I think Mr. Lanphier was making. But anyway, that's in just what happened here is that how the law was interpreted back then, the staff thinks we are now being told differently. You were wrong. Here's how you apply it. Here's how you interpret it today.
Okay, and I'm trying to figure out why the applicant feels cheated, and that's the word I'm using, feels cheated, because they made the application in good faith based upon what they thought was the law, and subsequent to that, they saw that law being applied in other applications, in their neighborhood perhaps, and now the rules are being changed to tell them that what they did, oh, by the way, you thought it was legal, probably was, but now we think it isn't. Am I off base with my statement there?
No, although it's all open to a matter of interpretation. Depends who you ask. The rules aren't so much being changed as the interpretation of those rules. And mind you, I understand that that's a definition only a lawyer could really appreciate, or like, for that matter. But that's the reality of what we collectively are faced with doing, is to interpret the law as best we can. That's what was done 15 years ago when Don Nickel was looking at these things. That's what's being done today with Ms. Bell et al. Based on resources available, in this case, a Court of Appeals decision, for example, and further LUBA decision.
And let me follow that a bit further. What we're saying by
the process check real quick. We are still in the public hearing on the record, so I want to be careful that we are asking questions that clarify the record and not getting into deliberations about a decision. So just if you'll keep that in mind with your questions.
Okay. Then shall I wait until I close the public hearing before I continue this? Because I have more questions surrounding this.
Sure, I think that would be appropriate. I think that's a good reminder. Normally, and I didn't notice, frankly, that we'll close the hearing once all the parties who came to talk have talked. Okay. We don't need to have the record open for the discussion and the sort of deliberation questioning we're doing now. So.
Very good. And any further comments before I close the public hearing? I will close the public hearing and continue with my question. My questions, I'm not questioning, that's not my job. I'm looking for clarification. And once again, 15 years ago, an interpretation of the law was made so that people thought they were obeying what is the existing law, made decisions, far-reaching decisions based upon what they thought they'd done quite legally. Now a new interpretation based on the Redco decision, which is in which county? Was that here in Lane County? Polk County. So it's not in Lane County, it's in Polk County.
But it was an appeals court.
It was a Court of Appeals.
And I knew that to be the case. But it wasn't in Lane County. But decisions have been made in Lane County that upheld the same applications that we're looking at today since then. So throughout this 15 years, the interpretation that was made 15 years ago has been used by Lane County. But now today, this day, we're saying, no, we were doing it wrong, and you're the first person that we're going to do it right on. Everybody else we've done it wrong on, but finally here we're going to do it right, and you're it. Is that?
Well,
I mean, I'm using harsh language there, but I'm putting myself in their place.
The issue of equity and how it applies to this applicant. It's not quite accurate to say that staff hasn't applied the Redco decision as we interpret it now prior to this.
Have they?
Yes. In fact, I think on a number of occasions over the counter, staff has done that. But today is not, this applicant's not the first one to sort of face the effect of that decision yet.
Okay, very good. Then let's move forward. Any further questions? Commissioner Williams.
Just two thoughts that are going through my mind and have been throughout this discussion is, and I'm not asking for conclusions, these are just thoughts and questions I have. One is original intent. And the other one, has the goalposts been moved? Those are questions that I'm looking at in my own mind. Has there been rules here at one point in time, and the goalpost is moved to a new set of rules, and what is or was the original intent? So I'm just struggling with that in my mind. As Mayor and Commissioner Lycan had said, it's hard to get your arms around this because it's very, very complicated. And
in which case, the Land Use Board of Appeals ultimately is going to consider the testimony that we've heard today and the testimony that's on the record currently. So, Commissioner Sorensen.
I was going to say that when I was in law school, I had this explained to me by another student because I was having a hard time grasping it. But it's like the Court of Appeals is more important than the Land Use Board of Appeals, just like rock, scissors. Okay, you know that game? Okay. So we have a Court of Appeals decision called Redco. And they have interpreted the law, all the LUBA decisions, and they've come down with a big finding. It's binding on everybody that's under LUBA. Under that, we have LUBA, and they make administrative decisions. They adjudicate land use cases that cities and counties have in front of them. Below that are cities and counties that have to adjudicate. Okay? So, in my view, I'm hearing the Redco decision is the major reason that the hearings official made the decision he made. So we can go and say, well, the Redco decision is wrong, and these folks can take this up with LUBA. They can then try to take it up with the Court of Appeals. They can try to reverse the Court of Appeals. If they can't, they can try to take it to the Supreme Court if they'll take it. Odds are, Redco decision is the law of the land. So that's where we are with my rock, papers, and scissors analogy here.
Good. That was pretty clear language. So what Commissioner Sorensen is stating then is that Redco supersedes every other decision that's been made on this piece of property and any other piece of property that's similar, subject to similar rules. And that's your interpretation, is that Redco is the final decision, and that from now on forever until there's another final decision, Redco is what applies. And that's why you're making the recommendation that you have made. Okay, very good. Commissioner Bozievich.
Thank you. So I'm leaning towards, affirming the hearings official's decision, and the reasons why are many. First is we do have an appeals court decision that basically talks about what a partition plat really does, and what we're being asked by the applicant to overturn in the hearings official's decision is to very narrowly look at it and say, well, because those property lines were set there by deed instead of a subdivision plat, it's different from Redco, and therefore you can make a policy call that those are still legal lines that were left behind after the 1984 partition. I'm sorry, but I've done multiple partitions in my lifetime doing, land use work in this state. I don't think a single one of them I ever intended to leave old lot lines in place. I can think of the partition next door to my current lot, which is a parcel that's actually a remainder parcel of a deeded out old 1950s circa deed, remainder to a family member. And the parcels next door were very similar, but there was a partition done there creating a 3-parcel partition. If the old deeds were left there, there would actually be 9 parcels of land next door to me in various configurations that would make absolutely no sense. At the time the 1984 partition was done, this was under single ownership. The old logging road was owned by the same people that owned the rest of the property. And they recorded 2 parcels. They didn't record 3, and they didn't go for a subdivision to have 4. If their intent was to leave 4 parcels of land on this, they should have done a subdivision at that time. Now, we may have made errors at Lane County in how we handled legal lot verification back in the early 2000s. I can't change that. But what we're being asked to look at is a policy decision by this board as to whether we agree with the fact that a partition erases previous lot lines. Because that's the core of this issue here. Does that 1984 partition eliminate those old deeded lines? And in particular, the lines for an old logging road that had gone into common ownership with the rest of the parcel? I believe it did. And I believe the Redco decision was right and applies in this case also. Even though that was about a subdivision lines underneath, I can look around this county at partitions that basically vacated previous deeded parcel lines. That's just, you record that partition, you are creating new parcels. There's no intent to leave old parcels in place underneath. So I have difficulty, looking back and wondering how our staff in 2003 came to some of the conclusions they did at that time. That's a whole different issue. And whether there's culpability and liability on the county's part for making those previous decisions, that's a completely different legal process. As to the remedies that those owners have against the county, that's not what we're being faced with here. We're being asked as a appeal to the Board of Commissioners, was because this might be repeated in the future, and it also involves a policy call, is do we believe a partition eliminates old deed lines? And my answer to that is yes, and therefore I will wish to affirm the hearing's official decision as our final decision. So that, understanding that separation of issues a little bit might get you away from the fairness issue, but that's really what we're being asked to decide here.
Thank you, Commissioner Bozievich, for that clarity. And would staff agrees with that assessment that the previous lines are erased? That's our okay, and that's what the Redco decision tells us. And the Redco decision is from a higher level decision-making body. Ms.
Right.
Clark.
That is the essence of our understanding of what Redco says. That's. And I was going to say in response to Commissioner Sorensen, you wouldn't probably get findings from us even if you decided to overturn the action, the hearing's official decision. You wouldn't get findings from us saying that Redco was wrong, because I don't think this board or LUBA really has the authority to say that. You could, if you wanted to, decide that Redco doesn't apply for various reasons. Commissioner Bozievich has articulated why he thinks it does. Mr. Farthing, of course, says why it doesn't. But the only additional thing is there are, I think, as I understand it, two other arguments the appellant has raised here outside of Redco and how it affects the lot lines on the paper. And one is whether this validation of unit of land somehow divided the property, leaving 1506 as now a separate legal lot. And then secondly, as Mr. Farthing has requested, to interpret the form, the legal lot verification form, to somehow find that it was final and conclusive at the time, and staff has already opined on both of those issues. So, but yeah.
Thank you. Thank you. Any further questions? Then we do have before us three options. And Commissioner Bozievich, I'm going to turn to you to make a motion.
So I'd like to move to approve the attached order affirming and adopting the Lane County Hearings Official affirmed decision as the county's final decision, and expressly agreeing with and adopting the interpretations made by the hearings official.
Do I have a second?
Second.
Moved by Commissioner Bozievich, seconded by Commissioner Sorensen. Discussion to the motion. Commissioner Lycan.
Thank you, Mr. Chair. So I believe that Commissioner Bozievich's arguments are correct on this. I do also believe that this piece, though, really causes me some concern. I mean, I think overall there were prior mistakes made, but the challenge is that I have is this. I started in business when I was in my 20s, and you know what? Rules changed all the time, and you had to adapt to them. And did it cost me money at times? It sure did. It sure peed me off too. So, but you had to adapt to those rules, whether they were coming down from the DEQ, Division of State Lands. It didn't matter. You still had to adapt. And I mean, I got to tell you, when my family first developing property, wetlands were regarded one way, and boy, that dial has moved significantly over the years. And so, but you had to adapt to it and work through it. But I am I'm concerned about this, and I think the question that I would have is, and this would be to the folks the applicants themselves and the folks who own the property. I remember when when we were going through the issue of Peace Health, we had folks come in and tried to stop it, and we got codification from the legislature. So the legislature actually changed the law to allow certain things happen. Whether that applies here, I don't know. That's up to other legal counsels involved. And that would be up to them to deal with it. But I think that the argument that Commissioner Bozovich made is correct. That's why I asked my question in the very beginning. If this was, in a sense, quasi-judicial, if it was legislative, then all of a sudden, to me, the rules would change from the board's perspective. But we're stuck in this. And I would, I'm not out to cost people money, but I do believe it'd be worth their effort actually to take this particular case and see what LUBA has to say. There are differences, I think, than Redco. There are some differences here that could be potentially applied. That's not what we're here for. And so that's my comment on it. I didn't want to second it. So I'm glad somebody else seconded on this, but I did want to make a comment on this in a statement. I'm troubled, but I think that we have really only one choice to do at this point in time. So thank you.
Thank you, Commissioner Lycan. Further discussion? Then, presuming that this is appealed to LUBA, and I'm counting votes up here, presuming this is appealed to LUBA, the appeal to LUBA would be based upon the application of Redco and not on Redco being wrong. Is that what I heard you say earlier?
Up to you.
Well, I can only presume that the appeal to LUBA, if this board upholds the hearings official, would look somewhat like the appeal to the board in terms of the arguments made, one of which would be, I think, that Redco doesn't apply. And I think if you get back to the Court of Appeals, that is appeal beyond LUBA, then you can make the argument, by the way, Court of Appeals, you screwed up when you issued Redco, you were wrong, here's why. And you can make that same argument at the Supreme Court if you really want to. But I guess I'm just trying to say that, yeah, at some point the argument for the applicant is going to be Redco doesn't apply. Once you get to the Court of Appeals, then you can start arguing, A, it doesn't apply, and B, even if it does, you wrongly decided it, fix it, so.
Okay. All right, very well. Further discussion? Seeing no further discussion, I will call for the vote. All those in favor, please say aye.
Aye. Aye.
Opposed? No. Passes 4-1. Chair opposed. Very well. Then we'll move along the agenda to Order 170926-07. And we have about an hour on this one. No, we don't. In the matter of reappointing Gary Rose, Randy Ledick, and Dwight Kuhn to the Lane County Planning Commission. Ms. Eichner. I didn't think it would take this long to get you back up here, but
It's okay. Good afternoon again. So before you today, like you said, we are requesting to reappoint Gary Rose, Randy Ledick, and Dwight Kuhn to the Planning Commission. They have served 1 4-year term, and they have all requested and are offering their time and thoughtful decision-making processes for another 4 years. The one thing I want to point out is that we recently have changed the rules for appointing planning commissioners, where we are only requiring one position to be a coastal representative. Gary Rose does fulfill that position, and so we will retain a coastal representative with a reappointment. We did have one member choose not to continue his service at this time due to circumstances, and so we will be posting for that position, and we'll bring recommendations back to the board for our one vacant position.
excellent. Then we have before us 1709-2607, Commissioner Bozovich.
So I'd like to move approval of Order 1709-2607 in the matter of reappointing Gary Rose, Randy Ledick, and Dwight Kuhn to the Lane County Planning Commission.
Second.
Moved by Commissioner Bozovich, seconded by Commissioner Lycan. Discussion to the motion. I see none. I beg your pardon. Commissioner Sorensen.
I think you're right. You didn't see him. I am just going to ask a clarifying question. The materials say that there are 3 open seats and 3 applications. I just want to make it clear there were no other applicants besides these 3.
Correct.
Yeah.
There is a 4th seat, and so I might have mistyped that in the
No,
in
you
there,
said
but-
there were 9 positions, 3 people applied for the 3 seats.
Yes.
Yeah, okay. Thank you. That's helpful.
Further discussion to the motion?
If I can make
Commissioner Bozievich.
If I can make one quick comment while we've got this open, is that to just thank Jason Thiesfeld for his service to the Planning Commission over several years here. He's moving on because he's starting a new business venture and has to, concentrate on that. But he's been a thoughtful member of the Planning Commission and has given lots of time to the community, not only here but up in Junction City. So I just want to thank Jason.
Thank you. Further discussion? Seeing none, I will call for the vote. Those in favor, please say aye.
Aye.
Passes unanimously. Thank you, Ms. Agner.
Thank you.
And our last regular item today is the first reading and setting the second reading of public hearing, ordinance number PA 1346, in the matter of amending the rural comprehensive plan to redesignate land from agricultural land to forest land and rezone land from the exclusive farm use E40 to impacted forest land F2 and adopting savings and severability clauses. Once again.
Mr. Chair, before we start, can I ask for a quick recess and confer with Mr. Clark on this issue? Just real quick on this particular issue. Just give me about 2 minutes.
We are in recess. Board meeting. Then we'd have, as I mentioned, first reading and setting the second reading on public hearing ordinance PA 1346.
And
Commissioner Lycan.
Mr. Chair, so if we could get before this, I would like to declare that I was business partners with Frontier about a decade ago. So I have not, there's been zero financial interest over the last 10 years. There was a decade ago, and I just wanted to declare that and just for the record. Thank you, Mr. Chair.
Thank you, Ms. Lycan. Commissioner Lycan, excuse me. And thank you, Mr. Clark, for that consultation. Then today, Mr. Rickoff, we have Amber Bell. Ms. Bell.
Thank you, Chair Farr. As you stated, this is a first reading for a privately initiated plan amendment and concurrent zone change to redesignate land from agricultural land to forest land and to rezone that same land from exclusive farm use E40 to impacted forest land F2 and adopt a savings and severability clause. The file number is PA 155828 and the applicant is Frontier Land Co. LLC. The property abuts the Notai unincorporated community just to the east of that. And the board is asked to set a public hearing for October 10th, 2017 at 1:30 p.m. in Harris Hall. Time certain.
Very well. Questions or comments? Seeing none, Commissioner Bozievich.
Thank you. So I'd like to move approval of the first reading and setting the second reading and public hearing for ordinance number PA 1346 to October 10th at a 1:30 time certain.
Second.
Moved by Commissioner Bozievich, seconded by Commissioner Williams. Discussion to the motion. Seeing none, I'll call for the vote. All those in favor, please say aye.
Aye.
Passes unanimously. Thank you for a long afternoon of work.
Thank you
and,
for your
well
time this
done.
afternoon.
Thank you. Then we're moving toward the end of our agenda today. Review of assignments, please. Mr. Rickoff.
Chair Farr, Commissioners, at this point I have the construction excise tax returning as a work session with a date to be determined, and with the last two assignments confirming the third readings for PA 1355 and PA 1356, I have confirmation that they will be on the November 7th agenda for the afternoon. No time certain needed nor scheduled.
And we also have a second reading of, did you mention that?
I did not. I was just I was just getting into the things that were work assignments for staff at this point, I believe, with the second reading.
Any questions or comments regarding the assignments? Seeing none, thank you, Mr. Rickoff. We'll move along. I believe that was executive session completed this morning. I was not in that executive session. We have no need for afternoon executive session. Then I'll ask for any other business from the board. Mr. Rickoff? Seeing and hearing none, I will adjourn the meeting. Thanks, you guys.
All right.
I learned.